Hi, good evening, everybody, and welcome to the first evening event as part of the UK Anti-SLAPP conference, Azerbaijan, SLAPPS, Media Freedom and the Prevention of Open Justice. The idea of our evening events was to have a broader conversation because SLAPPS are often just one small part of a much bigger story. And it can be one about censorship and corruption, not just abroad, but sadly, increasingly in the UK as well. Tonight's event is going to highlight the impact that UK's facilitation of corrupt wealth stolen by elites in autocratic regimes has on media freedom and democracy, both here and abroad. And it's going to do that through the examination of one particular story, which is the Azerbaijani Laundromat. And joining us this evening, both here in London, but also online, are some of the people who've been involved in telling that story. So joining us remotely are Khadija Ismayilova, independent investigative journalist in Azerbaijan, and Paul Radu, also an independent investigative journalist and co-founder and chief of innovation at the Organised Crime and Corruption Reporting Project. And here in London, Martin Bentham, Home Affairs Editor of the Evening Standard, and Dr. Susan Hawley, who's Executive Director of Spotlight on Corruption. For anyone who's not aware, the Azerbaijani Laundromat publication or investigation was published in 2017 by OCCRP, and it revealed a complex money laundering operation and slush fund that handled $2.9 million over a 2-year period through 4 shell companies registered in the UK. OCCRP reported that between 2012 and 2014, when this laundromat was under operation, members of Azerbaijan's political elite were using these funds to pay off European politicians, buy luxury goods, launder money, and otherwise benefit themselves. This was happening at a severe crackdown inside of Azerbaijan at the time, where independent media and wider civil society sadly continues to be under very tight restrictions. This evening is going to be sort of in 2 parts. One is going to focus on the story of how Khadija and Paul investigated the Azerbaijani Laundromat and the challenges that they faced in doing so, including a SLAPP case here in London brought against Paul and OCCRP. And then the second part is going to turn to the information that the Azerbaijani Laundromat was uncovering and the challenges that it then faced in London, and the reporting that journalists here like Martin struggling to find to report on what was happening when the National Crime Agency was trying to uncover those who were benefiting from the proceeds of the laundromat. So to dive straight into it, I might turn first to Khadija to give us a little bit of explanation as to what the situation was like in Azerbaijan when the laundromat was happening and where she started from in terms of her investigation. Khadija, over to you.
Hi. Just to make it clear, it wasn't millions, it was billions we were investigating there, and it started with 2.9 billion US dollars, and then while the story was while we've been uncovering new stories, looking into more accounts and data, then it went up to $1 billion first, and then up to $20 billion and more. So the story is not over yet. It still has some more to investigate into it. So with the about Azerbaijan, actually, if we are talking about the SLAPP cases here, it's very surprising for me, for example, why Azerbaijani oligarch would bother to go to London in order to get a court decision. In Azerbaijan, they control everything in judiciary. They can arrest people without proper excuse for that. They can They can charge them with absurd charges, and then including journalists. Some journalists are facing are facing charges related to their journalistic work, like it's officially the charge related to their journalistic work, but mostly they are using, some journalists were arrested by planting drugs into pocket. Some journalists were charged with drug trafficking or drug sale. Some journalists have been charged with financial crimes. So it's or illegal border crossing while being kidnapped in one country and taken to another country. So it's judiciary is in hands of the government. They can rule whatever they want against the journalist, against the media organization. Evidence we hear about dozens of cases against the media organizations, and some journalists get administrative punishment, including imprisonment for weeks of imprisonment, not only for stories they write, but also for the comments in social media that the story causes. So judiciary is totally under control of the government. Why would they bother to go to London? Probably later during the conversation we will touch that. We will find that answer. But about Azerbaijan, well, there is no independent judiciary that tells all about the country. But there is also no free media. So media organizations are either working in exile or cannot, are struggling in local circumstances because businesses are not allowed to advertise in independent media. If we speak about the numbers, there is no single independent or opposition print media in Azerbaijan. So you cannot find a newspaper, actually in paper, that would tell you independent or opposition or critical news about the government. There is no single broadcast media, I mean TV and radio, that uses the frequencies of the country that would criticize the government, the top level government. We haven't seen opposition on TV since 2013 elections, and in 2013 it was 4-minute presidential debate. So after that we didn't see opposition on TV. There is online media, and of course you can access Facebook and YouTube, so you have access to critical. But the websites, for example, the website that I write for, OCCRP, where Paul and we are working, and where Azerbaijani Laundromat was exposed, that website is blocked in Azerbaijan. RFERL Radio Liberty's website is blocked in Azerbaijan. Several other news organizations in Azerbaijani and international news organizations, their websites are blocked. For years, the blocking was absolutely illegal. There was no court decision. At some point, the government decided to legalize it, and they went and they secured the court decision to block the websites, some websites. And excuses are, for example, the story about the First Lady Mehriban Aliyeva. That is an excuse to block the website. It doesn't reveal any state secret. It doesn't go. There is nothing illegal in that story. But for that story, the website has been blocked by the court. So the situation is quite complicated. We have the new media law now that now requires us to register in the special registry, and there are arbitrary decisions. They register whomever they want. They don't register whomever they don't want. So basically, it's a licensed profession in Azerbaijan, and it is quite difficult. So I also work in a local media organization now, Toplum TV, and this is an online channel. Well, we face frequently the hacker attacks. The accounts are being stolen. By the way, they use the mobile phone companies to get into the accounts, and mobile phone companies also belong to the president's family. So so basically digital surveillance plus hacker attacks plus anytime there can be any inspection, and they can come and seal the doors. But I mean, trying is always worthwhile. So we try to continue working. So situation is quite dreadful, and well, but at least there is always newcomers to journalism, and a lot of people, a lot of young journalists want to do investigations. So there are some good news as well on that front.
Well, thank you, Khadija. And I mean, really thank you, because without all of your work, we wouldn't know what we know now with regards to this huge, and as you say, rightly, billions of money that's been laundered outside of Azerbaijan, and undoubtedly has helped the elite that then oppress media freedom at home stay in power. And I should mention, for those who aren't familiar, that Khadija has also been arrested many times and been in prison as a result of her work, and had judgments at the European Court of Human Rights in her favour, that she was targeted as a result of her excellent reporting. But I think that kind of neatly then hands over to the next part of the story, at least when it comes to the story of the Azerbaijani Laundromat and the fact that it was published in 2017. And that, Paul, maybe you can pick up as to what exactly happened next, and the case that you found yourself battling in London.
Sure. Good evening, and thank you very much for inviting me here. Thank you, Khadija, for your work. I mean, Khadija is a real huge thorn on the side of the Azerbaijani government. She's exposed crime and corruption related to the government in Baku for the past 15 years. I'm really proud to have been working with her, alongside her, and unfortunately, she had to pay a big price for her work, for her reporting. Now, this Azerbaijani Laundromat is part of a constellation of laundromats. These were money laundering schemes that were designed to siphon huge amounts of dollars, euros, and many other currencies outside of countries like Azerbaijan, but also Russia, also Kazakhstan, and many other countries, mostly in the former Soviet Union. And these money laundering pipelines, what I baptized as the laundromats, are actually places where corrupt officials, together with organized crime, can mix and match their money and can make investments abroad. What was really interesting about the Azerbaijani laundromat, because we worked on the Russian laundromat, we worked on an Iranian laundromat. Iran was very much doing the same as Azerbaijan. But what was particular in the case of the Azerbaijani laundromat was that money went from Baku all the way to the pockets of European Union politicians. So this was the big revelation with this project. We're talking about billions of US dollars, and a small part of that went to European politicians, but the deeds that they've done for that particular money was huge in terms of the repression that took place back in Azerbaijan. And I'll explain shortly. There was, for instance, this politician in the German Bundestag, the German parliament, who cashed in a few hundred thousand, I think up to 2 million euros, if I'm not mistaken, from the Azerbaijani Laundromat. Money was sent to his accounts in Germany. This same person went to Azerbaijan to observe elections in the country, and he certified the elections as being correct, as being accurate, as the results being, honest and all that. Although in one particular instance, the government released the results for the election 2 days before the election took place. So this was the kind of money that was transferred through the Azerbaijani Laundromat towards politicians who were in the Council of Europe, politicians who were in various parliaments in their respective countries. And the cost was again huge for the people in Azerbaijan, like Khadija Ismayilova, who went to jail, who had spyware put on her devices, who was under surveillance for a long time, and so on. All this is the result of that money. Now, what happened after we published is that there was a lot of upheaval. There was a lot of uproar about this, because finally we had the proof, and this was collaborative work. We worked together with other media to expose this laundromat and other NGOs as well. There was a previous report that highlighted some of the findings that we've exposed with the Azerbaijani Laundromat as well, called caviar diplomacy. So all this kind of rolled, and its impact was big in the sense that politicians were banned from the Council of Europe, and Azerbaijan finally found itself in the ropes, because suddenly the public could see that this dirty money, a lot of the money was actually looted from the banking system in Azerbaijan and from other places. A lot of the money was from various very interesting sources, like Russia's Rosoboronexport, which is one of the main weapons export companies, was putting some money in this laundromat, and so on. So people could see the extent of the corruption, not just in Azerbaijan, but in the West, in Western Europe. And as it was mentioned before, at the core of this laundromat were British companies. So the British company system was used, because the registration agents that were putting up these companies to be used in the laundromat were linked to these British companies. And sometimes they were British themselves. We published, and a bit later, I received a notification in my country. I'm Romanian. I received a notification that I need to show up in court in Bucharest, in the capital of Romania, because there's a demand, some legal demand against me. I looked at that paper. I said, "Well, okay, that's interesting. What is this?" And then it was clear to me that this was a court case that we're now calling SLAPPS. That was a SLAPP because there was one of the subjects of the investigation of the Azerbaijani Laundromat was suing me and my organization OCCRP in London, although he was an Azerbaijani oligarch, an Azerbaijani politician, the liaison with the Council of Europe in the EU, and so on. So this person sued me, and at first I was quite surprised, because everything that we publish is fact-checked, is evidenced. Everything was based on banking records that we verified to the bone. It was all very, very clear. It went through a legal process. It was lawyered. So I was pretty sure that the case would be dismissed in London, that no judge could accept such a case. But to my surprise, I had to go to London, and the court started. The court case started, and there were many, many parts to this court case that were quite hurtful to an investigative reporter. There are other SLAPPS, and there's people like Catherine Belton, who was sued for this type of stories as well, exposing oligarchs and all. But the main point for me was how powerful these oligarchs can be by using the British court system to muzzle the press. One small example. As part of my court case, I had to undergo a process called discovery. Many of you are lawyers in this group here, and in the audience, so you're very familiar with discovery. I wasn't. To me, the fact that I needed to give up the contents of my laptop, of my phone, of all my electronic devices, where I keep sources, where I encrypted a lot of stuff. The fact that I needed to give that away to a third-party company for the party that was suing me to be able to search for various keywords in my content, that was quite damaging, and it was a huge and very unpleasant surprise, because guess what? The other party asked for a list of keywords that contained, for instance, the word Azerbaijan, the name of the country. Well, that could have revealed a lot of documents that had nothing to do with the story itself, but that pertain to ongoing stories, ongoing investigative stories, and stories that my colleagues are working on. So this is a very, very damaging, highly damaging process. And obviously, in order to defend yourself in London, you gotta have money, you gotta have great lawyers. And I was very, very lucky to have amazing lawyers, amazing British lawyers on my side, who understood the problem and who helped the investigative process, actually. So this was one of my main takeaways from this court case. We settled in very favorable terms with us, but the fact that you need to cooperate with lawyers in order to slap back, basically.
Thank you, Paul, for that really fulsome explanation. I think it's worth mentioning. Sorry, Khadija, did you want to come in?
Yes, I would like to add something. The very fact that Mr. Fayzev's appeal to the court in London was accepted was actually absurd, because that story, the story about Avramed company using the shell companies, Laundromat companies to deliver their money, it was the mildest story of the series. So yes, the story contained a claim, not a claim, actually a fact, that the member of parliament owns a company which is illegal. And then it was saying that this company was actually using this Laundromat scheme to transfer their money, which was also suspicious, but well, it should be, the court should decide if it's illegal or not. Well, anyway, the story was the mildest comparing to other stories in the Laundromat. Like, according to Azerbaijani standards of corruption, it was the mildest case in that Laundromat. Well, Mr. Fayzev somehow got very angry and went to London court in order to punish the media organization that wrote about him. Why London court? Because it's expensive, because not many journalists can afford going through that process, and it's an international media organization that has. But the very excuse he used in the paperwork he wrote, it was written in his application that he goes to London court because his family lives in London and he spends most of his time in London. This guy is a member of parliament in Azerbaijan and has to be, and probably has a full-time job in the parliament of Azerbaijan. And he claimed he spends most of his time in London, and London court accepted that.
Thank you, Khadija. I think it's worth mentioning just at this point that at the Foreign Policy Centre, we started researching SLAPPS actually through this project called Unsafe for Scrutiny, which we started a couple of years ago to look at all kinds of risks and threats to journalists who uncover financial crime and corruption. And there are many violations that have taken place against Khadija and other journalists, but also Paul's case. Paul's case was the only SLAPP case that I'd really heard going to court before starting this project, and it gave us a bit of a signal that not only was the UK somewhere that this dirty money was being serviced, but also the source of places that could shut down, or services that could shut down scrutiny of it. And one of the first things that we did when we started the project a couple of years ago was a global survey through OCCRP networks and others of journalists that uncover financial crime and corruption. And we were asking them all about all kinds of risks and threats. And it was legal threats that came out the most strongly as the challenge to continue. And I think, as we've heard today, we understand why that is, because of the huge costs and time and resources it takes to defend them. But the UK was also identified as the leading international source of those threats. And for me, that was such a key as to why. Why here? And part of the questions that we had put into the survey, because we were interested in the link with the UK, was had the journalists in their investigations come across a direct or indirect link with the UK, so whether that's like shell companies or buying property here, sending their kids to school here, for example. And 61% of the respondents said that there was a definite link, direct or indirect, in their investigations to London. And then you start to understand how they build a reputation enough here to defend if they're buying property here, if they're spending time here, even if they're a sitting Azerbaijani MP that you think should really be spending their time in Azerbaijan serving their constituents. But Paul, you wanted to come in here.
Yeah, I just wanted briefly to put it in a bit of a broader context. I mean, SLAPPS in London are one tool in the arsenal of these oligarchs, these kleptocrats. And it's really about when you expose their infrastructure, the infrastructure that allows for them to do the crime and to profit from the crime, that they really get mad. And when they get mad, they try to muzzle you in your own country. But as you heard from Khadija, you know, despite everything they've done against her, and they've done a lot, they couldn't silence her. So then they went against the organization that was supporting Khadija with her work. That was, you know, one of the reasons of going to London, in order to silence the international voices that they couldn't silence inside their own country. So this is really about the long arm of Azerbaijani corruption reaching into London and using London lawyers. And unfortunately, this is where a big part of the problem is. At OCCRP right now, we have 41 SLAPPS against the whole network, 41. A few of these are in London. But it's really, when you look at everybody who sued us, what you see is a big number of oligarchs that we exposed, corrupt politicians, and a very, very small number of lawyers and law firms from London representing them. You also see these same law firms servicing these oligarchs and their interests in other ways. Just one example. When I was reporting with Khadija on the wealth of the first family of Azerbaijan, we've exposed and exposed and exposed, and at one point, the Azerbaijani government decided enough. We got to stop these people from exposing us. So what they did was they shut down access to the registry of companies in the country, in Azerbaijan. So from that moment on, you couldn't access anywhere the registry to find out who are the shareholders, the beneficiaries of the same companies. Now, just recently, I should point out, a few days ago, there was unfortunately a ruling by the European Court of Justice where, at the initiative of two people who wanted to, or three parties who wanted to remain anonymous in terms of their ownership of European companies being secret, being hidden, there was a law firm who represented them and managed to score this victory against transparency, against democracy, against investigative reporting, you know, in obscuring, you know, and in forbidding access to this type of records in the EU. This is something that we're still quantifying, is still rolling. I think the implications are going to be huge. But this is just the same thing that happened in Azerbaijan almost 10 years ago, happens right now in the EU, you know, at the pressure of the same people, basically.
And if I'm not mistaken, a British law firm that brought that forward. So I'm sure we're going to come back to that, particularly in some of the comments from Sue. But I feel like now is a really good moment to turn to Martin, because since this court case with Paul was settled in January 2020, there's been some efforts by the National Crime Agency here in the UK to follow up on where some of this dirty money through the Azerbaijani Laundromat ended up. And there have been a number of investigations, but we may not have heard as much about them if it hadn't been for journalists like you going into the court, and in particular challenging court order anonymity orders that some of the lawyers were getting on behalf of their clients while they were being investigated. So, and these are, I think we're in sort of 3 or 4 cases now where, we're getting this sort of remedy and redress, but way too late. And so maybe you could tell us a little bit more about that.
Yes, I mean, just to say, Paul very nobly there did probably understated completely the stress and so on that being subjected to that litigation must have inflicted on him, because the time and effort and worry that would inflict, I can only imagine. And that's a reason in itself to be very concerned about the use of SLAPPS. Now, my issue is not about SLAPPS, because I haven't been targeted by them, although even tonight, the second case I'm going to talk about, I have to be careful, because there's still a risk of litigation in any of these cases if you say the wrong thing and go a bit further than the court has found. So in my case, my concern is about the use of Article 8 privacy claims to suppress identities, and there are 2 cases that I've been involved in, both of which involve the laundromat, with people here receiving money that has been found to have come through the laundromat, and investigating property and so on in this country. The first case involved a couple called Suleiman Javidov and his wife Izzat Kanim Javidova. Now, originally somebody told me about said there's a case that you want to be interested in, and they said the name is Javidov. I knew nothing else about it. There'd been no listing in court of any sort, although there'd been some freezing order hearings. And to cut a long story short, I was going to go to a hearing on the 2nd of December 2019. As it happened, there was a terrorist attack at Fishmongers Hall just before it, so I was diverted by having to do that, so I couldn't attend the hearing. I then applied for the documents in this case. Their side opposed the documents because I wanted to find out what was actually the case was about, of course, because we couldn't write something just on the basis of a surname and no knowledge as to how much was involved, what the case was, or anything else. And the Chief Magistrate, Westminster Magistrates, agreed to hold a hearing to discuss it. It actually ended up being 3 different hearings because of adjournment, and then their barrister taking too long to complete his submissions. Anyway, eventually she ruled in my favour and said that the documents should be disclosed. But at the start of this discussion, their side had said we want to bring a judicial review of whether the case on the December the 2nd should have been in open court or not. As a result of that, the Chief Magistrate put a stay on disclosure of the documents and also imposed an anonymity order on the couple concerned. So I had bare facts that I could say, report that there was a case of this sort and roughly what it involved, but not any more than this. And then the process went to the forfeiture hearing. At the start of the forfeiture proceedings, their lawyer, who'd said that they would be accepted that the names would come out at the end of the process, suddenly said we want full privacy for the forfeiture hearing, which is due to be the following year, a 10-day forfeiture hearing. And he said we want full privacy for that. And I also argued that while this judicial review, which they'd got going, was ongoing, the names should remain suppressed. And so there was basically an attempt to use every single legal mechanism, fighting about 3 different angles. And there was then a separate hearing on the anonymity scheduled for the March of the following year. They basically changed their solicitors for that hearing the day before, so they turned up with no evidence whatsoever. But then the judge said, we've got to give them a chance to produce this evidence, and to cut a long story short, so then there was another hearing. Eventually there was a hearing, proper hearing. The judge in that case then ruled that anonymity should be lifted, but again gave them the right to, they wanted to bring a judicial review of that decision. They then had an application on paper for a judicial review refused. They've then given the right to an oral hearing, also refused, and then they tried to take that to the Court of Appeal, and it was only refused at the Court of Appeal on the day that the judicial review into the first hearing was refused, only 3 days, well, less than a week before the actual substantive forfeiture hearing was due to start. So it was nearly 2 years from my first hearing about this before I could actually name the couple and the details, and basically there were 9 different hearings I had to attend, some of longer than others, before we got to the end of it. All along, they were just claiming that they had they fought a very poor case, actually. They were claiming that there would be damage to their reputations, their businesses, but they most of the time failed to produce any evidence at all and just tried to use legal procedure to argue that it was the wrong time to identify them. But the result of it was, of course, and in that case, I wasn't facing a cost threat. There was just a war of attrition that it was nothing as compared to what Paul and Khadija have faced, but it was a very time-consuming thing that, frankly, for my paper, if they'd really known how much time I was spending on it, it wouldn't have been cost-effective for them at all for it to have happened. At the end of it, there was a settlement in the hearing. They agreed to forfeit £4 million from their accounts, which was about, I think it was about 13 point something million that had actually gone through their accounts. They bought 4 properties. None of that was part of the settlement, but clearly there was a finding by the court that they had benefited from the Azerbaijani Laundromat, and all along they'd managed to keep their names out of the public domain, and could even have done so if they'd managed to succeed all the way through until the completion of that settlement. And I think if we hadn't got the result just before, the actual forfeiture proceedings would have started without their names being made public, and because there was a settlement, it may never have come out. So that was one case. The second case was the Feziev case, which relates to what Paul has been talking about. In that case, the son, wife, and nephew of Javanshir Feziev, the person who sued Paul, were subject to forfeiture account forfeiture proceedings by the National Crime Agency, which ended with 5.6 million being forfeited from their accounts. And there were incidentally adverse findings by the judge in that case against Javanshir Feziev, and some of the evidence that he'd put forward in the defamation proceedings against Paul said that some of that was called into questions needed to be answered about what the accuracy or otherwise of that material was. And that hearing was certainly very illustrative of the unjustified litigation that Paul faced as a related issue. Part of that case, and now I'm now fighting another court battle related to that case. Somebody who was part of that case, not the subject of it, but their name would have come up in the proceedings, except that on the morning of the proceedings, they suddenly applied, his legal team suddenly, which we didn't know about at all, suddenly made an application for anonymity. The judge granted that. I then challenged it subsequently after the forfeiture proceedings, and they were finding that these 3 people had benefited from money from the laundromat. I then challenged it, as did the BBC, and the judge agreed to lift the anonymity on this other person who was involved in the proceedings. But we've not been able to name him as yet, because he again has sought a judicial review, lost on the papers, but has managed to get permission on an oral hearing. So there'll be a High Court hearing next year to decide what happens in this case. But this is another example of Article 8 privacy. He just claims that there'll be irremediable damage to his reputation, his businesses, and he has significant interest in this country. I can't say more than that. A person of significance, and the court the judgment found that he was a person of importance in the case, and the findings were that some of the money that was forfeited had gone via his account. Some of the companies involved, some of the laundromat companies, were owned by him, or he was linked to them, and so clearly he's a significant person who, I would argue, his activity should be exposed to public scrutiny. Now, I should stress, not least for legal reasons, that there's been no finding of criminality against him, or indeed against even the Feziev family, because the proceedings are all about the money, and whether the money itself is dirty or not. It doesn't make the account forfeiture proceedings do not make findings about the recipients. It just says you've got dirty money in your accounts, proceeds of crime in your accounts, and it's got to be forfeited. So just to clarify that, but clearly the argument of someone like me and others would be, and I'm sure many people in the room would say, people of that sort, we should be able to know that they've received monies of this sort or been conduits for it. They've been involved in companies that are conduits for it. And it's in the public interest that if we're talking about having a clean financial system, clean property market, and so on in this country, that these Article 8 claims, often based on just assertion, should not be tolerated and should not be accepted. And in this case, what's happening is that the ZXC case, ZXC versus Bloomberg, which people here will often quite likely know about, which involved a finding against Bloomberg about giving privacy and saying that privacy should be given to people who are subject to criminal investigation, before they've ever reached any court proceedings, is being extended now into court cases where traditionally there's always been a principle of open justice. The starting point is that participants in the case should be named, and the public should be able to understand who's before the courts, who's being named in court proceedings as witnesses as well, and that only in exceptional circumstances should those people's identities not be revealed. And those exceptional circumstances have to be justified by clear and cogent evidence, and not just on the basis of mere assertion that it's a bit unpleasant to be identified as being connected to people involved in receipt of problematic money. So we're getting a very difficult trend happening, in my view, where Article 8 claims are being increasingly used to stretch into court proceedings and try to throw a blanket over what's happening in court proceedings at the expense of the public's right to know and to be able to scrutinise where monies have flowed to in our financial system, in our property market, and so on. And I think it's something that urgently needs addressing and rectifying.
Thank you very much, Martin. And I mean, it's almost farcical what you describe. And I remember when we spoke about this before, just in one case, you had gone to nine court appearances. And I mean, as you say, it's not a slap, but it's still taking up your time and resources, or the Evening Standards potentially.
For most newspapers, that sort of thing is just not time effective, really. It's just not, because, especially increasing in the world of online clicks and getting traffic on your website and everything else.
Well, exactly. But thanks to your reporting and challenging those court-ordered anonymity orders, we do know that the NCA seized 4 million in July 2021 from the Javadovs after they accepted that the money came into the UK unlawfully via the Azerbaijani Laundromat. They entered the UK through the Golden Visa scheme, which I might ask Sue to explain a little bit more about in a moment. And Mrs. Javadova was granted citizenship in February 2018, which was the same year that the NCA started investigating them. And just to touch back upon, Mr. Faziev, who sued Paul, it was January this year, so exactly 2 years after the settlement, a UK court approved the NCA's seizure of 5.6 million collectively from members of his family. And those weren't the full amounts that the NCA were investigating. And as Martin's already made the point, these were civil seizures. These were not criminal investigations. So even if they had been, potentially happening much earlier, I don't know exactly what the impact would have been necessarily for someone like Paul fighting the case. But the problem is we don't see things that way around. We see the journalists' investigations first, and then the attacks on them, the cases that we've talked about, the attempts to keep investigations into their wealth undercover, and then we get the redress, 10 years on now, and partially, arguably, and it's not just Azerbaijan, is it? So I think
I think Paul wants to come.
Oh, Paul, sorry, I was going to hand over to Sue there, but Paul, did you want to come in?
Yeah, just one second. I just wanted to say, I mean, the work that Martin, has done on this Azerbaijani Laundromat is amazing, and it's really helpful for everybody, because as we saw in the Azerbaijani Laundromat, lots of journalists unfortunately got bought with that kind of money. And we've seen generally outside of the laundromats, that a lot of the media got bought in many countries and is in the pockets of oligarchs. So I think this the work by Martin, by PI UK, by other British journalists on the Azerbaijani Laundromat is just amazing, and it's so helpful. Thank you.
Well, it's nothing as compared with what Paul and Khadija have done.
Well, I always like Paul's phrase about taking, a network to fight a network, and I think there are all these different parts of the network, and it's all very much needed, particularly as I was about to say to Sue, it's not just Azerbaijan, and here we are hearing about the UK facilitating. It's four shell companies, 2.9 billion, and then the legal cases, and now these court-ordered anonymity orders. What's gone wrong, and what can we do to fix it? Two very light questions for you.
It might be like, what's gone wrong for who and what's going right for other people.
True.
I think it's such a fascinating discussion and amazing to be in the room, or virtually as well, with such heroes who are doing incredible work. I think I wanted to pick up on something about the importance of the courts that Martin was saying, and the role they play, the kind of vicious cycle in a way that you're getting between what's going on in the courts and SLAPPS, and the negative impact it's having on the UK actually enforcing the law against people. I was really struck by what Khadija said about how Feziev is just like a really, really minor part of this Azerbaijan laundromat, and that, that's what we've got so far. But I think it shouldn't be up to Martin to get a quiet word in the ear, that there's a case going on. These are public buildings, and we're paying for them to be, some people would say we're obviously not paying enough, but, they're judges. And it's as if this whole public system has been kind of repurposed in somehow to actually be like a playground for oligarchs and very wealthy people. I think that's a phrase you also use in your report, Susan, that it is, and as Paul said, this isn't just about SLAPPS. It is, a whole system that the lawyers that they're using to bring defamation cases are the same lawyers who are turning up and taking these cases which are just designed to wear journalists like Martin down and rack up such costs by, coming into court with banks of barristers and KCs that it makes it incredibly intimidating for anyone to actually get to the bottom of, what's going on in the courts. But I think we also have to remember that this is also what the UK law enforcement faces. And just to say, we have seen this anonymity thing, it's definitely creeping throughout, the UK court system after this judgment that Martin referred to. And it's having a huge impact on the ability of journalists, or the willingness of journalists to investigate stuff. And as we've also seen, in the kind of, a virtuous feedback is where you get reports from, Khadija and Paul and the OCCRP, and they form the basis of law enforcement investigations. I mean, we've seen that with Global Witness reports as well, that getting stuff out in the public domain about what's going wrong is key to law enforcement, and it's key to people in government who want to impose sanctions on people. They need that information out there. And so, we're getting this kind of feedback loop between the two things that is really, really worrying and really damaging, because you can see, when you see how it's applied to law enforcement agencies as well, you see how these cases get dragged out. So the first sanctions evasion case that the UK has tried to bring, it's already been sent all the way back to square one, because the lawyers are just, managed to play every single trick in the book that there is. And I think it just has this incredibly negative impact on the ability of law enforcement. And they themselves are very scared of bringing these cases. And I think you see, like another case involving oligarchs from a Central Asian country, which has been under investigation for 10 years, and every single legal case that could have been brought has been brought to try and undermine this case, undermine the prosecutor. And I think at the root of it is something that is extraordinary deference, actually, of the UK courts, which I think Khadija referred to, is this deference to privacy claims and a deference to people turning up with these huge banks of top counsel, and thinking sometimes, certainly in some of the cases that we've monitored, it seems easier to give in to these cases than for the judges to actually want to manage these cases and say, look, this has got to be wrong. We've got to crack down on this kind of legal abuse going on.
Just speaking to what you were describing, and these sort of endless hearings and being allowed to appeal and then appeal again. How can we cut through that? Is there a way to cut through it? Is it just reliant on the judge maybe seeing through these things? Is it a lack of maybe contextual knowledge by our judges, perhaps, and just wanting to kind of go by the letter of law? Are they worried at all about maybe their judgments coming back on them in some way? I
think that's part of the problem. I think certainly, and it's not just me thinking this, I know certain senior barristers who think the same, that the judges don't always, they won't take a decision. So if you look at the application for a judicial review, people can have an application dealt with on the papers. If they lose it, they get another go in an oral hearing. What's the point? One or the other. And similarly, even then, they can challenge that and seek leave to appeal at the Court of Appeal, which, if granted, of course, will then spin it out even further. So I do think the judiciary need to look at the way that some of these cases are dealt with and at least have a filtering out and say there is no realistic prospect of this case succeeding, end of. That's it. Because otherwise, if you constantly have this idea that you've got a right to another hearing, another appeal, all the time, it's cost, it's attrition, it's time, and it makes it very hard. It plays into the hands again of the wealthy. And just to digress as well, in the current case that I'm involved in, the challenge, the anonymity being removed is the defendant in the litigation is the court, but the costs can fall on the interested parties, which includes me, and that it also seems to be wrong that you're an interested party because you were the person who helped, or one of the people who helped to actually get the anonymity order removed, and yet you can be hit by cost just for trying to stand up for something which a court has ruled in your favour for, if that's subsequently overturned in the litigation stage of judicial review. That's not my fault. If the judge in the substantive hearings is deemed to have got it wrong, that's the judge's fault, and yet the cost liability can fall on me and other interested parties. That has also got to be a fundamentally wrong thing and a fundamentally problematic deterrent for the media standing up in these type of cases and pursuing them to the death. And in this case, it may not be able to do that for exactly this reason, because this person is heavily armed with 3 KCs at the top rank, for example. So anyway, so I think there are areas that's just in the procedure that can be certainly tightened up and made less onerous for people to have to fight the cases.
I think, definitely more judicial training, which came up in the last panel actually about legal ethics. We do need a proper kind of system, but almost like the Ukrainian anti-corruption court, where you have judges who are properly trained in economic crime cases and who are aware to and prepared to take on these abusive practices by lawyers, because it really shouldn't be the case that, we're a rule of law jurisdiction, but essentially, as keeps coming up again and again, if you're wealthy, that rule of law is heavily skewed in your favour. And that's whether you're a journalist, it's whether you're a law enforcement agency, it's whether you're an NGO fighting, or a journalist from abroad fighting a SLAPP. So I think there's that. I think the other thing that's really problematic is a kind of acceptance of evidence from jurisdictions where we know, as Khadija was saying about Azerbaijan, that evidence should not be accepted because the whole of the judiciary in that country has been completely captured by the ruling elite. And we've seen this in the second unexplained wealth order that failed in the UK was, the fact that papers had been signed off by the very authorities that were run by the person that was part of this elite, was accepted without any question by the UK courts. And that kind of issue of evidence is also partly the base of why only some of these sums are being able to be frozen and confiscated as well. But I also think this fact that the law enforcement agencies are only going after the low-hanging fruit is because this is how hard it is just to go after the low-hanging fruit. Why would you go after the really, really big?
Just to digress, one other solution, of course, I think also should be that when there's talk about legislation in Parliament to counter SLAPPS and to strengthen Article 10 rights in that, it also ought to be looked at in respect of Article 8 privacy claims as well, and that may need to be what happens, so that the Parliament gives a lead to the courts to say, when you're balancing the rights of Article 10 versus Article 8, Article 10 needs to be given even greater weight than theoretically it's meant to have at the moment, because that may be the only ultimate solution. Otherwise, these Article 8 claims are going to continue ad infinitum and with damaging effect.
Thanks. I'm conscious that we are almost 2/3 of the way through and we haven't turned to any questions. So if there's anyone in the audience who's thinking of some questions, just keep them in mind. And similarly, for those watching along online, please do submit your questions in the chat box and they'll come up here. I just wanted to pick up quickly on a couple of points, which I think are interesting. One was around judges. And I did think that Justice Nicholan's decision in the NRC case that against Tom Burgess in relation to his book and HarperCollins earlier this year was interesting because, for many reasons, but also he refused the right to appeal. And ENRC has, as I'm sure you know better than me, Sue, but launched a lot of legal proceedings. I think it's 18 cases at one of the last counts against various different people who've tried to speak out about the company. And it has also sued the Serious Fraud Office that has been investigating the company for 9 years. I think maybe it's 10.
Coming up to 10.
Coming up to 10, yeah. Which just really speaks to the very slow moving pace of these investigations and clearly the many obstacles that are being put in place. You mentioned unexplained wealth orders before, and maybe there's some people who might not know what they are, but could you maybe just touch upon like the different tools that have tried to be introduced and where we're at now, maybe with things? And there's been obviously a lot of sort of traction in light of the ongoing war and attempts to put, there's an economic crime bill 2 going through. So where are we at now?
So we're very good in the UK at passing laws. We have had 2 laws, well, one that was passed very rapidly after the Russian invasion of Ukraine. And these were measures that are about tightening up some of what Paul referred to in terms of why UK companies are so popular as a vehicle of choice for laundering money, and why UK property, luxury property, has been another really top choice for, I'm sure, not just Azerbaijani MPs. Well, we know not just Azerbaijani MPs, but many kleptocrats around the world. So these new laws, some of them are really, really welcome. We've got some really great, if they were going to be implemented and enforced, they're long overdue, but they are really important. I think a really good example in that emergency legislation back in March, the government did make the unexplained wealth order regime easier to use, but actually there's only been one unexplained wealth order since that hasn't yet come out, and which we think is not to do with, dirty money from abroad at all. And I think there's, some real issues as well emerging about, we saw in one of the Azerbaijani Laundromat cases, the use of a civil settlement as a way of tackling this. And the thing with the civil settlement is no information comes out. The problem with it not being heard in open court is, you don't find out who are the names of the people. And I think a lot of people felt with that settlement that it was really seriously letting, these people off the hook, and that it wasn't proper justice. But we're in a situation where our law enforcement are just so under-resourced, and they're so desperate for quick wins, that a civil settlement is the best way, of getting some kind of result, and then they can move on and try and, and get something else. So I think, there are really big questions here about, and it's really encouraging to see Parliament, as these bills go through, saying, how are you going to put proper money into law enforcement? Because frankly, until we create, a law enforcement regime in the UK, which is a bit like the US one, where it is actually, instead of these top barristers servicing, the oligarchs and the kleptocrats, they want to defend SFO cases. At the moment, the SFO struggle. They can't pay top fees. They don't get, top dollar. I mean, that's no offense. There's some great barristers who working with them. You have to be careful what you say, but basically, the whole of the justice system is an inequality of arms situation, whether it's journalists, whether it's law enforcement, whether it's individuals facing, defamation proceedings. And so until we tackle costs, we actually resource our law enforcement. And I think this anonymity thing is really important. I mean, we're working on another case, nothing to do with Central Asia, another, very, very significant case, a former prime minister really should be back in his home country facing jail time, applying for all sorts of things through the courts, completely secret because of anonymity. So I think there's some shoots of hope that the UK suddenly thought, well, we've actually got to do something about this, and there was a kind of reckoning, and a lot of people in government were like, let's seize this moment to actually try and clean up the UK's act, but until we really tackle enforcement, I think there's this sense that these bills might end up being paper tigers.
Just to say very briefly, of course, in these cases, you get account forfeiture, so money is forfeited as proceeds of crime, but there's no follow-on prosecution of anybody for any criminal activity, because, of course, that requires a different burden of proof, and there's all the resource implications and so on. So it's easier to go after the money, get the money, and then not bother with the criminal side of it. And so, again, that's all down to lack of resources,
and
really.
What does the NCA do with the money that it's seized?
Well, in these civil recovery cases, some of it they do get back, and then some of it goes to the Treasury. I think that's a really good question. In one case involving Pakistan that's become actually very, very controversial, it did go to Pakistan, but it went back to pay the fines of the particular individual to the Pakistani court. So it didn't actually benefit any of the guy's victims in Pakistan. So I think there are lots of really live issues around, how do we get the right balance between making sure that this money is ploughed back into law enforcement so they actually, can get the top expertise to bring cases, and how can we make sure that some of it goes back to these brave journalists in countries like Azerbaijan.
I was thinking about Khadija and the European Court of Human Rights judgments, which did award you some damages, but I'm not sure if you saw any of that.
Well, part of the money that I won as a compensation in European Court of Human Rights have been seized by the government of Azerbaijan to pay the fines they decided to put. So, and the judgments are not executed in Azerbaijan because, well, European Court of Human Rights demands that I should be acquitted of all charges. I won the case in 2000. I won one case in 2019, another case in 2020, and I'm still waiting for execution. So, at some point, the Committee of Ministers, they started monitoring the process of the execution, and I had a call from the prosecutor. He invited me to talk, and I went there. He asked if my attitude to the government has changed. I said no, and they said then they can do nothing about that. So they do not execute the judgment of the European Court of Human Rights because my attitude to the government have not been changed. So they think I have an attitude. So this is what happens with that. But I want to reiterate on something that Susan said about low-hanging fruits. Yes, it is a big problem that only former officials or their family members or some politicians or oligarchs who are no more in favor in their own country are subject to unexplained wealth orders. So that's a very bad signal. That gives an impression that money can do anything. Actually, like this is what should we accept it as a reality of like these people who are depriving their own people, the people of this country, oligarchs and government officials who are depriving their own people from benefits of democracy, like good education, good health care, or transparency and independence of judiciary. So we lack access to all these fruits of democracy. But these people who are also wealthy, they can buy apartments in London, they can spend time in London, and they can enjoy all of this fruits of democracy. And and when unexplained wealth order comes, it is very selective to those who are still have power in their own country and probably worldwide. These people who have power in Azerbaijan, they probably have power in London too, in UK too. So this is a very bad signal, and it tells something about independence of judiciary and independence of the law enforcement in from foreign powers in UK as well.
Can I add one thing, which is that, the thing that we always, we bang on quite a lot about in our court work is that voices of people like Khadija are never heard in the UK courts. You never hear the people who are actually directly impacted by, as you so powerfully put it, Khadija, being deprived of the fruits of democracy. And it's something that, we
at the
bang
time
on
when
about.
Excuse me, at the time when I was a witness in Faziv's case, when Paul was sued by Faziv and I was a witness, I supposed to testify in the court, and I was under travel ban in my own country, and I lost the case in Azerbaijani court when I applied for permission to go to the trial and come back.
Thanks. But I think this is a really key point. And again, speaking about the Unsafe for Scrutiny project, we started it after the UK had announced the establishment of the Media Freedom Coalition 3-4 years ago, together with Canada, and it said that media freedom was, its priority, foreign policy priority, which is great, but completely seems to be a disconnect with understanding how media freedom violations are, funded, and how the link with corruption, and that actually, if the UK wants to have an impact and improve situations for media freedom, statements are not going to get you very far in countries like Azerbaijan, but hitting them by tackling the corruption and the facilitation of the crop wealth here would actually start to have an impact. So this is I hope one of the stories that can kind of really bring that to full circle and to make that point. The concerning thing, of course, is the impact it's also having here. And what Martin was talking about in terms of the challenges that you're facing to then report on this. I mean, I think you were saying about you end up going around in circles in some cases. Again, I'm conscious we're now in the last 15 minutes and we haven't had any questions. I think there was a couple of questions from the floor, and I'm conscious to give Paul back a question regarding next steps, but maybe if there's a question here.
Hi, and it was so about Martin. I mean, one of the things that we've experienced in SLAPP work is we can plan these things and they take long. You try and, but then you have lawyers who are acting for the oligarchs who have this suite of things they can do. If they lose that, it's fine. They'll get they'll push for an anonymity order. They're so agile, so fast. They're able to know. It feels like they know our political system better than the campaigners who are trying to really bed it down like human rights standards. How do we? I mean, I guess the optimistic question is how do we respond to that? The pessimistic question is can we respond to that? Because how can we respond to these people who know the system so well? They know exactly which lever that they can pull and which little procedural step that they can sort of tweak. And how can civil society, journalists, human rights advocates, the good guys, for lack of a better word, how can we respond in the same way? How can we be as agile as they can?
I mean, I don't know. Paul's nodding. I don't know whether that's an invitation to. Oh, it's a big question. But I don't know if you. I mean, particularly as you say, you're facing as a network 41 SLAPP suits at the moment. Has the experience helped you develop better ways of pushing back?
Well, yes, and it has definitely not stopped us. Although the definition and the goal of these labs is to stop journalism, and we went big at it. I mean, the first thing to understand is, as was mentioned right now from the audience, is that these people have many avenues to follow. If they stole summer, they can attack you, in a very different place. It's a whole industry, it's a whole ecosystem that's built against investigative reporting, against activism, against lawyers who are honest, and so on. So understanding how that works is the first step, and that's done through investigative reporting. And that's done through alliances. That's done through our cooperation with people like Martin, with people on the other side of the ocean, and so on. I mean, without these alliances, you don't get the whole view, or a good view of what these oligarchs can do against the public interest. Because all of this is against the public interest. They don't want their businesses to be exposed. They want to keep on looting. But this ability of theirs to use various jurisdictions at the same time, this ability of theirs to travel across frontiers and so on, is also their kind of weak point, their weak spot that we can follow, that we can identify in order to expose their corrupt networks. And these corrupt networks include, unfortunately, lots of enablers in the UK law firms and US law firms and others. Our 41 court cases right now are not just in the UK. I mean, we have cases in Switzerland, we have cases in the US, we have cases in many other countries. Many of these are local SLAPPS where oligarchs are going against our journalists. For instance, the Center for Investigative Reporting in Serbia, in Belgrade, Creek, has more than 10 cases right now against them. This is harassment. This is just about stopping them from doing their work. Now we are fighting back, and in order to tackle this problem, you got to think big. And we're starting very soon this initiative. And I think tomorrow you'll hear more from my colleague and dear friend Alex Papachristou from the Vance Center for International Justice about our Reporters Shield, which is basically a new organization to defend investigative reporters around the world against legal threats that are meant to silence, all these critical voices. So OCCRP and the Vance Center, we are creating together this organization that will help journalists free up the investigative reporting that they want to do. Because one of the chilling effects of SLAPPS is the self-censorship. And this is a huge problem. There's so much work that investigative reporters need to do but cannot do because of these SLAPP kind of cases. And they need to do this work. They need to show the public what is going on. So Reporter Shield, our initiative, and my co-founder, Drew Sullivan, worked a lot on this in the past years, will offer measures to prevent lawsuits. There will be training and review of investigative articles before these articles being published. We will offer legal assistance to fight SLAPPS. So the idea is that we do need to fight back in a global way because the UK is one jurisdiction where SLAPPS happen. There are a lot more out there. And Reporters Shield is our way to protect news organizations as well as NGOs, activists. It's really addressing an industry-wide need, because unfortunately the response to date, and I was really, really lucky, to have really good lawyers in the UK, and others have been lucky, but there are so many investigative reporters that don't have this opportunity, so many activists in South America, in Africa, that don't have this chance to have access to really great lawyers. So we're kind of trying to create a system where they can benefit from this protection, where they can really be able to do their work, to continue doing their work, without all these problems that are put on their way, by oligarchs, by corrupt politicians, by British law firms, US law firms, and all these enablers, or as we call them, the criminal services industry.
Thank you, Paul. And it's extremely exciting that something like that as a potential defense is going to be launching soon, and I'm sure we're going to hear more as well from Alex, who you mentioned is speaking tomorrow. Just to link into a question that's come in on the chat about reporting to the SRA, and I'm not sure if you're aware, Paul and Khadija, because it only came out earlier this afternoon, but the Solicitors Regulatory Authority here in the UK has put out a warning notice, and it sets out sort of more specific guidelines and sort of rules of engagement, or not how to engage, importantly, when it comes to certainly the writing, the pre-action part of this process. And someone has been asking about the fact that everybody knows who these law firms are, and isn't it time more people started complaining about them, including law firms themselves? And my question was kind of two-part. One, I guess to you, Paul, what your response is, having been through this process in London, what difference do you think that having that SRA warning notice is going to make? And if you were receiving letters now, would you be reporting them to the SRA? And then the second part would be more to kind of sue about the professional bodies and regulations. And I know you've had a recent report looking at kind of a broader view of lawyers and their role in this area. So maybe first to Paul and then to Sue.
I've actually read the recommendation earlier today, and it was a really great surprise. Someone posted it on our OCCRP internal emailing list, and it's great news. I don't think it will stop the lawyers who are currently engaged in this type of practices, but name and shame still works. I think younger lawyers might think twice before joining a law firm that's really about SLAPPS, and it's really about helping kleptocrats rob their people. So I hope that's that there will be at least a partial effect on these law firms, because what they're doing is really out there. I mean, you see not just them attacking journalists, but you see them working in the favor of these oligarchs, against this, in the favor of these kleptocrats. You see them helping them secure their investments, and this is something that's really that shouldn't be done. It's against the public interest totally.
Stu, just in terms of regulation. Oh, sorry, Khadija.
Yeah. Well, there is one more thing. First of all, the defense of the whistleblowers is a very important part of the investigative journalist, and I think more efforts in that direction would really help. And the second thing is, you said about the chance for people to be heard in the courts, in the UK court. But it's not just that. For example, in Laundromat case, there was a whistleblower who would speak more if there wouldn't be a slap threat. So the way out is to have him to speak in British Parliament. But British Parliament was too busy since 2017, first with Brexit, and then with pandemics, and then with changes in the government. So there is never time for corruption to be discussed, or so. If, for example, that witness speaks in the UK Parliament, he will be free to speak, and he can avoid the slap threat. So I think it's time to engage more lawmakers into that process.
Thanks, Khadija. I mean, there have been, interestingly, a number of committees this year that have held evidence sessions on SLAPPS. I don't know what the scope is. I mean, of course, there's been some committees that have been held in relation to the economic crime bill too that's going through at the moment. I don't know what you think of that suggestion. Do you think there's scope that we could try and get some committees to do one-off evidence sessions on the topics of the laundromat and bringing investigations?
I think as part of a bigger investigation, I think it's worth noting that some MPs have also had slaps against them, and that these same people are spotting where they might have said something outside of Parliament, so they're watching MPs closely, so it's not foolproof. But I think there is a real opportunity with whistleblowers in that, there is now one of the new ministers in the current administration is really, really passionate about whistleblowing. And I think a little bit like SLAPPS, we're starting to see a kind of shift, things that felt like impossible, before, you are starting to see a shift. And I think that, that's about finding the right MPs to invite the whistleblower over in the right context. And, people like Margaret Hodge would have done that like, a shot. Like we need, to hunt out those MPs and find the right opportunity to make that work. But I just wanted to say as well a bit on, I thought that thing about making it really unacceptable and young lawyers not wanting to go and work for these people is really key. And I thought it was really inspiring, the panel before with Dan Needle saying, no, I just published the letter and said who was the people who were bringing this case against me. And he was a commercial lawyer, so he had the knowledge to do that. And I think it's that thing of and that's why this coalition is so amazing, because it's starting to empower people to think, I could do that too, But I think the thing with the lawyers and incentives is so hard, because we're in a situation where, someone in a city law firm within a year or so earns the same amount that the director of the Serious Fraud Office earns. It's like, how do we change the incentives of people who, their whole incentive structure in those firms is not to ask questions and to bring the money in. And so I think we've got quite a long way to go on legal ethics, actually, and actually really changing it so that it feels unacceptable to be engaged in that kind of activity.
I mean, I think and I said it earlier, I think part of the reason there has been this traction on SLAPPS is because people have spoken out about it. And I mentioned earlier that Paul's case was one of the few cases that I knew about when we started this project. And I remember having an early conversation with Paul about it and asking, was it intentional that you didn't have a lot of media coverage about it? There was some NGOs that had been speaking out about Paul's case, and obviously your lawyers had put some statements out, but there was not a whisper from the main sort of media outlets. And Paul said, no, we were just really busy fighting the case, and we hadn't necessarily had time to think about engaging that. And so, even still now with Carol's case at the beginning of this year, I didn't see a huge amount of solidarity, but I do think that has been shifting. And I think it's so important that, obviously hoping that these conversations helps with that, and that people feel confident, like Dan did, just to go, no, I'm just going to publish this, because it's not that, easy for people to do that, especially if they're targeted as individuals, and they don't have the wider resources.
Well, I think that Russia's invasion of Ukraine is obviously one thing it has done. The only good thing it's done probably is to focus attention on this type of issue and to strengthen the arguments for media freedom and against SLAPPS, and indeed not just SLAPPS but other litigation as well, simply because clearly people have seen that these type of cases have previously been brought by people who are now being sanctioned as being Putin cronies and so on, and that and it's really brought a focus on that. So I think there is a moment now, isn't there, to try to capitalise on this, not just in terms of trying to tackle dirty money, but also trying to tackle the abusive processes that can be used by people who allegedly have been in receipt of such money and are using the courts to try to suppress people, trying to highlight and criticise that. So we have a positive moment at the moment, but just and also just on journalist and legal ethics, I should say. I mean, another thing that I sort of object to, of course, people are entitled to representation, but it's when lawyers use every single device in footballing parlance. They play the man, not the ball. So they argue about the forum, which court it's being conducted in, whether the litigation is in the right format, and so on. They don't address the substance, and it's a telltale example, of course, of illustration of why their case is often deficient. But you often see this, and clearly they must have a sense that the cases they're putting forward on the actual substance are not really there. They're just trying to divert attention, bog down the opposition. Yes, in all sorts of satellite debates, in effect, that obscure focus on the actual substantive allegations of misappropriation of funds.
Well, I'm very conscious that we've actually reached the end of our allotted hour and a half. So I would say that we probably have some homework there in terms of maybe getting Dame Margaret Hodge, who's actually speaking tomorrow, and seeing if her interest around committees and getting some of the evidence as suggested by Khadija. But in the meantime, may I ask everybody to thank Khadija, Paul, Martin, and Susan for what's been a really interesting discussion, and hopefully there'll be more things coming out of this in the future. So thank you.